Good morning. I'm Rosalie Schaefer, and on behalf of the League of Women Voters of Manatee County, I welcome you all here today. It's very good to see such a good turnout for this topic. Today we're going to be talking about an issue we don't hear much about, the loss of the right to vote for some 10% of Floridians. You know, that is a really major issue. A major part of the community is not allowed to participate in democracy. In most states, convicted felons may vote after completion of their sentences. However, in Florida, a past felony conviction can mean a permanent loss of the right to vote. Florida is just one of 11 states that continue to restrict voting rights even after a person has completed probation or other terms of a sentence, even for minor felonies. And they may wait on a long list, waiting for a hearing forever. Can you hear me? Okay. Okay, is that any better? Okay. Unfortunately, Representative Roussan could not make today's program due to a scheduling conflict. However, we are very pleased to have with us today Michael Barfield of the American Civil Liberties Union and Larry Eager, Public Defender for Manatee and Sarasota counties. After their presentations, we will invite questions from the audience. At that point, please use the microphone on the floor for your question and state your name. Okay, without further ado, we will begin our program.
I want to start by thanking you very much for the invitation to come to the League of Women Voters. By way of background, I always like to include the fact that my mother was the president of the League of Women Voters for Sarasota County some years ago, so I too am a member of the League, and I just want to compliment the good work that the League of Women Voters has done. My entire life, I've had to endure it when I was a child, and now the work that she did, and I really think the topics that you've chosen to concentrate on are significant, and I look at what's going on right now with the redistricting and the work that the League has done to get that moving. So I compliment all of your hard work on that. Myself, give yourself a round of applause, absolutely. So you know I am not quite a lifetime resident, came here in '68, and I've been here ever since, and my entire legal career has been with the Public Defender's Office, and that's going on now. I'm in my 30th year with the Public Defender's Office as an attorney. I don't know if I should be applauded for that or not, but it's just a fact. I didn't, and the issue has been for the 30 years, what happens to our clients and how they can reintegrate into society once they have, if they are convicted or have pled, and what happens to them. And this is a very important issue that we had a brief hiatus during the 4-year administration of Charlie Crist, but since then we're back to where we were before, and I think that that's where the conversation will go. I just did want to correct the 12th Circuit, of which I represent, is Sarasota, Manatee, and DeSoto counties, so we don't want to forget them in this role. And I'm going to let Michael introduce himself.
Thank you, Larry. Michael Barfield. I serve as Vice President of the ACLU of Florida. The ACLU, as many of you know, in my mind, is the go-to civil liberties organization in the state of Florida that advocates on behalf of the full range of constitutional rights that we all enjoy and that we all need protection from, or protect our rights. So the ACLU has 4 offices spread throughout Florida. Our main office is in Miami. We also have regional offices in Tampa, Jacksonville, and Pensacola. We have 29 full-time staff members, 5 of which are lawyers, and we advocate on behalf of all citizens of the state of Florida, and I want to emphasize all, across the state in both federal courts, state courts, all the way up to the Florida Supreme Court and the United States Supreme Court. We have about 18,000 members in the state of Florida. We have worked hand in hand with the League of Women Voters on a number of important issues, including the redistricting battle that is played out, which is really a part of the felon disenfranchisement that occurred post-Civil War back in Florida. So we love that you are a partner with us in that litigation and the results of it in terms of where we're going for redistricting, because that's an important component in the disenfranchisement of voting rights that Florida, sadly, has become famous for. Another caveat, I'm often mistaken as an attorney. I'm not an attorney. That's Larry's job. So I'm a paralegal. I do a lot of work with civil rights, and my day job and my volunteer capacity is as vice president of the ACLU. So that's a little bit about me and our organization that we represent. By the way, we also have a chapter here in this jurisdiction, the Sarasota Manatee DeSoto chapter. We kind of follow jurisdictional patterns along the legal system. And our meetings are monthly in downtown Sarasota. Occasionally we move it around, first Thursday of the month at the Selby Library in downtown Sarasota. So I want to go back and start with a little bit about the history of Florida's felon disenfranchisement provision that was contained in the original Florida Constitution and the subsequent amendments that occurred, just to sort of educate you about where this provision came from and why we believe it was a racially motivated provision inserted in our Constitution. Following the Civil War, Florida actually voted, of course, to not in favor of the 14th Amendment, to make all laws subject to, or all constitutional provisions subject to the rights of citizens in this state. They voted not to rejoin the Union that had lost the Civil War. And there were a number of things going on when the convention was held as to whether Florida would be readmitted to the states that was under consideration. Initially, there was a disenfranchisement provision that was inserted in the language of the draft version of the Constitution, but it was not very restrictive at all. A group of individuals known as the Radical Republicans basically took control of the proceedings and inserted a very broadly worded provision in the Constitution. This was in 1865. And that provision is the source of the constitutional prohibition that bans felons from being able to vote in the state of Florida. There was no secret about what the motivation of it was. There were quotes of members of that group called the Radical Republicans that made it unambiguous that it was targeted at blacks to keep blacks from voting in this state following the Civil War. And in fact, they were in contact and had communications. It's been very well documented by several historians with ex-Confederate leaders that were openly advocating for white supremacy, that this was the reason why they put this broad provision in the Florida Constitution. So after that, when Florida was readmitted to the Union, there were efforts made, whereas crimes that before were that would invoke the disenfranchisement were basically treasonous offenses. Now it was virtually anything could get you disenfranchised. And at first, it was for these more serious crimes as felonies, but eventually the legislature reclassified many misdemeanors as felonies, but only did so along racial lines. And our criminal justice system focused on prosecuting individuals for these offenses, specifically to keep blacks from being able to register to vote following Reconstruction. At the same time, the reapportionment scheme that the radical Republicans came up with was to take representatives in densely populated African American communities in Florida following Reconstruction and dilute the representation in the Florida legislature for those particular areas. So that's why I talk about reapportionment and felon disenfranchisement go hand in hand. And this is very important because of the recent efforts that your organization, along with ours, has been involved in to, with Amendments 5 and 6, to have fairness in our apportionment of voting districts in the state of Florida. Those two go hand in hand, and we can't not consider one or the other. As it presently stands, 1 in 10 Floridians have permanent bans on being able to vote in Florida. 1 in 4 African American are banned from voting in Florida because of felon disenfranchisement. We lead the nation in felons being and voters being disenfranchised through this onerous provision in our Constitution. There's only 2 other states that have permanent bans, but neither, that's Iowa and Kentucky, neither of which are as onerous as Florida. They're more reserved for particular categories of crime, whereas in Florida, it's all felonies. So as the most recent figures that I have is it's approaching 2 million in Florida of individuals who are permanently banned from being able to vote in this state. Now, a lot of people talk, and Larry mentioned it briefly, about the changes that we had when Governor Scott came into office in March of 2011, where he overturned progressive measures. They weren't great, but they were at least a step in the right direction that Governor Christ had implemented in terms of making it easy. There was an automatic restoration at that point in time that Governor Christ and other members of the cabinet had agreed to, where you didn't need to do anything. Under certain circumstances, your voting rights would be automatically reinstated. Governor Scott, as one of his first acts after he was elected, was to change those rules, and now we're back to the same system where there's a huge backlog. There's a minimum waiting period of 5 years or 7 years, depending on the nature of your offense. But in reality, individuals have been waiting many, many years before they get their rights even considered to be reinstated. So that's a little bit of our framework. As many of you know, there's currently a petition drive going on to amend the Florida Constitution. There was there are some deadlines that are coming up that make it very important to be able to get this before the Florida Supreme Court to review. So signatures are needed to be able to do this. I just came back this weekend from an executive committee meeting with the ACLU where we are going to make this one of our top priorities next year. We may not, given the timelines, have enough signatures to get this on the ballot for next year and to have time for the Supreme Court to consider it prior to the election next year. But we're already looking ahead to 2018 and 2020. We've invested some resources in doing some polling as to what language would be the most acceptable to the 60% that's required to amend the Florida Constitution to remove this onerous provision that keep people from voting. But those are some of the things that we're working on, and we encourage you to help us in that endeavor. And one of the first things you can do is sign that petition that's back on the table in the back. I'll turn this back over to Larry to talk about some things that I omitted, but he has more detailed data, I think, than I do. So back to you.
I think Michael covered just about everything. By the way, and I said before this was a dialogue, if at any time you have a question, please do not hesitate to raise your hand. And you're pointing over here. Oh, I'm sorry. Or I can walk down with a microphone. I don't want to bore people with statistics, but as Michael had indicated before, there are approximately 100. Do I have the number? Let me double check my numbers so I don't mistake it. We've got 100,000 people in prison in the state of Florida. The United States does have the highest incarceration rate in the world. We represent 5% of the world's population, yet we have 25% of the incarcerated. Yes, I see a question.
Population of Florida?
I failed demography, so no, I do not. 20 million, I was told, and the Department of Corrections is releasing approximately 32 to 33,000 people every year, which are at this point are permanently disenfranchised. We have one of the largest disenfranchised populations in the world, and we seem to concentrate on the black community, but quite honestly, what I see from my perspective is we have disenfranchised the poor, because by virtue of being poor, you are subject in a different capacity to the criminal justice system. Your opportunities of release, your opportunities of fighting the accusation from outside of jail, there are so many symptoms that that weave into this fabric, so that it's not just one thing. And I address it strictly from the criminal justice system, from being the public defender who represents. Last year, the 12th Circuit, we represented approximately 26,000 cases, which indicated approximately 19,000 individuals, half of which were felony cases. Now, I don't have. Do you have a question? Yes. If you ask, I'll just repeat the question.
Would you explain what a felony is, please?
Okay, what distinguishes all right, that's a very good question, and I'm sorry I didn't address that earlier. What distinguishes a felony from a misdemeanor offense is obviously a lower level crime, and a misdemeanor offense basically is defined by a crime that is punishable by up to 11 months, 29 days in the county jail. If you are convicted of a misdemeanor, you are not subject to the loss of your civil rights. A felony, by definition, is any crime that is punishable by up to 1 year, all the way to death. That's a felony offense. So there's two categories of crimes. Now, within those two categories, there are different varying degrees, but the general assumption of what distinguishes a misdemeanor from a felony is just that. And if you are convicted of a felony, you lose all civil rights. You cannot vote. You cannot possess a firearm. You cannot have a professional license. You are barred from many housing as well as educational opportunities. And it is a blemish that is, or that scarlet letter that stays with you in this community forever. Yes?
What are the types of crimes that fall into those two categories?
The question was what type of crimes, and really there's an ebb and flow, but what seems to be happening is that more and more misdemeanors seem to be elevating themselves to felony status because of our legislature, and there are really too many to go into details. I mean, a simple battery. If Rob Atkins here, who was a probation officer from years back that I dealt with, when he would make me angry, if I felt like hitting him, that would be a felony because he's a law enforcement officer. But for Rosalie, who's not a police officer, if I hit her, it would just simply be a misdemeanor. So I'd lose my voting rights if I was convicted of that. This one, that also goes for me. If I hit a state attorney, that's a felony because he's a law enforcement officer. But if a client hits me, it's just a misdemeanor because I'm not considered a law enforcement officer. But so there are too many to go into details, but it is the severity of the crime.
Why are they penalized for not being able to get, you said something about education?
They're prohibited from getting certain grants. Universities do not. For instance, you cannot practice law in the state of Florida if you're a convicted felon. Regardless of what the felony was and what you've done to accomplish, your degree and success. So it prohibits many universities, and even when you look at job applications, and there's legislature that's been presented that can't be on the preliminary questioning so that people are weeded out before they even get a chance to be interviewed. Yes, they are. But again, these are sort of token, and I didn't repeat the question. The question was, why you can't get, why you are prohibited from getting an education if you are a convicted felon. And that's not across the board, but there are many institutions that prohibit you from getting the admission. And again, on a simple job application, there's one job, there's 25 applicants, and if you have on that, have you ever been convicted? It even goes more than just convicted of a crime. Now the applications are asking things of, has there ever been a finding of probable cause? Have you ever been arrested? And so do you want to hire somebody who's even been arrested? Well, I can just push that person aside. So we have that process. I see that we're going to play the Phil Donahue show regardless.
Okay, I have a question. Isn't it true that a lot of these convictions are drug-related, simple possession?
Well, looking at just admission to Florida State Prison, the latest statistics that I have, that 32.6% are property crime related, 31% are violent, and 23% are drug related. So really 2/3 are, and again, how you want to define violent crimes versus nonviolent. It's snatching a purse is considered a violent crime, even if there was no violence that was exerted in the effort or minimal. Breaking into a burglary is considered a violent crime, even if it's a garage that is unattached from the house. So. Or a vehicle that is considered a burglary. So we can debate the issue of violence, and that's why you have judges who are supposed to be able to determine on a case-by-case basis the merits and designation. But we have the legislature instead, which has designated the classification of a crime. So yes, there are a number of cases. And as I was saying before, with the number of people that are released from prison, the likelihood of being released earlier is that you've committed a nonviolent offense. So you are releasing people who have served their sentence, who are permanently and I say permanently disenfranchised. During the Crist administration, I believe there was 120 to 150,000. Again, I have to look at the numbers here. I had it written down somewhere. 150,000 individuals whose civil liberties were restored during the 4-year period of time. Can anyone guess how many people civil rights have been restored since in the first term of the Scott administration? No, it's not 0, but it's 1,200. So there's, and Michael wants to add.
One thing I wanted to add is that we expect people that come out of prison to become productive members of society. At least we would want to hope, I think, that that's what we would expect them to do. But these laws that not only ban them from participating basically in the most important democratic process that we have, voting, it goes further. There are numerous jobs that you cannot get in the state of Florida because of a prior felony conviction, just an automatic ban. And on top of that, we have data from other jurisdictions, other states that don't have a permanent ban. Maybe it's a short ban or whatever, but the recidivism rate, this is very important, the recidivism rate for people whose rights are restored is significantly less than those whose rights are not restored. So it, to me, is a big incentive. We want people to return to society. We want them to become productive members, paying their taxes, etc. If we're going to accomplish that, the restoration of voting rights and these restrictions on employment and participation in the community are very vital to that process. So that's, to me, a very telling point of why these laws, aside from their racially animus origin, that we should get rid of them. Yes.
Hold on, let me get the microphone.
The Donahue Show.
Hi, on a practical basis, and I'm new to Florida, I haven't really voted here yet. I'm a snowbird that just bought a home. But let's say I lived here a couple years, showed up at elections every now and then, and let's say I was arrested. I assume, what, on a practical basis, how, if at all, is my name removed from the voting records here, or from the election day person, the polling person guy there, the registrar, whoever, if I show up after 5 years because I've been in prison, and maybe I decided not to vote for 5 years, and then showed up and gave my name and address, how do they know that I was a felon? I guess, how do they know that I was a felon, is my question.
Well, the supervisor of elections in each jurisdiction has a detailed procedure by which they check available data. They have access to what we call FCIC, Florida Crime Information, Computer Information, whatever, network, NCIC, and they check those periodically to determine whether they should remove someone from the voter rolls. Florida has a history of doing that, not just for felons, but for people who they think may have died. There was examples right here in our own jurisdiction a couple of years ago where people were wrongfully removed from the voting rolls. When they showed up at the polls, the pollster said, "Our records show you're dead." So that process is tainted, and so it's a fair question that system by which you are removed from the voter rolls if you're suspected of having committed a felony is not infallible. So I hope that answers your question.
You know, to further confuse things, what state were you from? All right, so, and I don't know what the laws are in the state of Wisconsin, but for the sake of argument, let's assume that after you've completed your sentence and if you've completed probation or parole, that your civil rights are automatically restored. There you are, a voter in Wisconsin, but you move to Florida, and all of a sudden, now you can't. And then you move to another state where you can't, I mean, so there's no continuity, nor is there any uniformity. So it is entirely dictated upon the state where you will reside as to what your rights are. So it is the confusion that is created. And so this is where, I mean, Florida has a very interesting history, both going back from the Civil War, but if we even look at recent history and the number of voters that were taken off the voter registration during the Bush-Gore election. I mean, that was supervised under Katherine Harris, and it was, you know, you purged them. There were lots of mistakes. Now, there were lots of attempts at correcting it, and there were reviews of it, but there's no way of determining who was actually turned away based upon that. You can, if you go to vote, you can demand that you be given a provisional ballot to vote so it can be clarified so that your vote can eventually count, maybe, depending upon the outcome of the election. But it's the lack of consistency. And you'd like to think that the right to vote is not, remember, one thing that I can't emphasize enough, your driver's license is subject to suspension because driving is a privilege. And so the state can regulate any way they want. And believe me, nobody wants to go up against the Department of Highway Safety and Motor Vehicle. But the right to vote is just that. It's a right. And so that's where, personally, I feel I tend to be as inclusive as possible. And I don't, you know, to the extreme, we looked to Vermont, where you can be sitting in your jail cell and they bring a mobile voting device so that you can cast your ballot. So there are extremes. We just happen to be, I believe, on the wrong extreme.
To that point, I've just returned from Australia, where it is mandatory that everyone vote. and there is a substantial fine if you do not vote. And when you ask them why they have that, they said, how else could you have a representative democracy? So there are other ways. And Australia, as we know, was originally founded by a lot of convicts and people who had problems. And there is a different way. So.
Comment. Well, that's an interesting comment. I don't know if any of you have heard about the efforts right here in Florida, again, where prisons that are predominantly located in North Florida, where this is the height of hypocrisy. They are including prisoners that are located in their prisons for purposes of population for determining where district lines should be drawn. So, in other words, if there's a prison in Marianna, Florida, which there is, and there's 3,000 prisoners there, the legislature is saying, well, they're citizens, they're humans in the state of Florida, and they count for purposes of my district for representing them for drawing the district boundary lines. So to me, it's just the height of hypocrisy that we're going to recognize that and draw the lines by which we put them in prison to enable that legislator to have more power, but not to have those individuals have an actual voice. If none of you have, by the way, have read this book called The New Jim Crow, it is a book that really painstakingly recounts the efforts by legislators throughout the South to use the apportionment and disenfranchisement laws to restrict the rights of the minority to be able to vote in this country. It's an excellent book. I suggest that you read it. Yes, sir.
No problem. Oh, for the recording, sorry. Given that it seems like there's a procedure in the legislature or in the state government for felons to get their rights back after 5 years, but it's basically being ignored and deliberately slowed down. If that's correct, I mean, it would seem to me that it would be grist for a suit attacking the fact that you have this procedure and you're operating it so poorly and you're procrastinating so much that it's prima facie evidence that you're violating the policy. Is there such a suit like that currently underway?
The short answer is no. I will tell you that the ACLU has twice litigated this particular issue in a facial challenge to the Florida Constitution ban on the grounds that it violates the 14th Amendment and the First Amendment. While we had some success at some stages of those lawsuits, ultimately the 11th Circuit Court of Appeals in Atlanta ruled against us, and the United States Supreme Court denied certiorari. So we lost that case that we brought back around 2005. We are looking at what remedies we have available to address through litigation the slowing down of the process, the throwing molasses, if you will, into that process by which the rules are being abused, and even after the 5 or 7 year waiting period, where individuals are still waiting years to get their rights restored or to even be considered to have their rights restored. But that's a very individualistic, depending on the individual circumstances of each and every applicant, which is why we were always in favor of the automatic restoration once certain criteria had been met. We had always been willing to say, as a bottom line, our backdrop position, that we would be in favor of the automatic restoration after a certain period of time, 3 years, 5 years, to eliminate the very thing that you're talking about, that process that's interminable for someone to go through rights restoration. But Governor Scott and the cabinet rejected that, and so has the legislature.
One way to avoid felonies is to have a better sentencing rather than mandatory guidelines, to have more flexible guidelines and not penalize people for calling them felonies. If they have 3 driver's license or 3 misdemeanors, suddenly they become a felon. And that's just ridiculous to have felons with those things, with those charges.
I don't know if that was a question or statement, because I agree with it entirely, but the act of decriminalizing something is not easy. And you know, you look to the legislature, and they're not there to not pass laws, or they're not there to retract laws. They're there to create more laws. And you know, as a public defender, I always follow the guideline that if a statute has a name attached to it, I can assure you it's bad law, because it's usually reactionary. You're right, and that's what I was saying earlier as far as how do I just describe a misdemeanor compared to a felony. It's in a state of flux. The 3rd driving while license suspended charge is a felony. You can have your license suspended for failure to pay child support, or for, I mean, there's any number of unrelated, or failure to pay your fines. Why can't you pay your fines? Because I can't afford to. But why do you drive? Well, I have to go to work. You know, so we've created this tautological argument that you're right. Minimum mandatory sentences in and of themselves don't create felonies, but we're trying to address, and I think that realizing the incarceration rate and the arrest rate, the wheels are falling off the wagon. We can't, you know, we can build the prisons, but we can't man them. You know, and I'm looking at, not only are we talking about incarceration, you know, quite honestly, when I was invited to speak here, I thought I was going to talk on the subject of the criminalization of mental illness, but it turned out to be a different subject altogether. So, but you know, you have criminalized poverty, you've criminalized mental illness, and this is where I look at, and I don't want to become overly technical, and I might confuse the situation, but you know, you get arrested. The presumption is that you are not guilty, that you are innocent, that the state has the burden to prove guilt. Yet, at first appearances, which you are brought to court within 24 hours of your arrest, the judge reviews the police report and determines whether you are a threat to the community or a flight risk. But the law is clear that there's a presumption of a non-monetary bond. Yet, we have the lowest rating of non-monetary bonds in the country. National average is 30%. We have less than 6%. So you get, if you're my client, you're my client because you can't afford representation. If you are homeless, if the bond is set at $100, which you and I might think that's easy, it might as well be $1 million. And so that client sits in jail. And the next formal court date is either a bond reduction hearing, if we're lucky enough to be appointed at first appearances, which I make the argument we're supposed to be by law. But you sit there until your arraignment date, where you are, this is where you have what's called cash register justice. And the National Association of Criminal Defense Lawyers did a study, they call it 3-minute justice, whereby, and you heard the volume of cases. I mean, remember, I said 19,000 clients. I've only got 45 lawyers in my office. So you do the math as to what we process. And we end up, and I think, again, I'm going to stand here and tell you that my office, and on the whole, the public defenders system across the state delivers outstanding legal representation. Could we do more? Are you entitled to more? I say yes. You say no, because you don't want to pay more taxes. But that's just the reality. So I'm playing the hand I'm dealt. But the client sits in jail until their arraignment, and what is the likelihood of them pleading out at that time? If they're offered time served, are you going to fight the charge, or are you going to plead to it? So there's your first driving while license suspended charge, or your first petty theft, or it might even be a felony offense. So we have created this class. And so, you know, again, I can say to the statistics, If you are black and between the ages of 18 and 30, you have a 1 in 3 chance of either being on probation, parole, state prison, federal prison, or county jail. 1 in 3. That's the national average. You go to urban areas, it's closer to 60%. And more statistics.
Well, when I first heard about Amendments 5 and 6 years ago, my initial reaction was, well, really, why don't we consider a constitutional amendment that bans the legislature from meeting except once every 10 years? Because they do more harm each legislative session than anything that I know of. But, you know, seriously, it is every year. Legislators come forward with a bill with their name attached to it or some victim's name attached to it, and it's they're running for re-election, and they have a get tough on crime approach. And so we have all these laws that I don't know how one could quantify the number of felonies, the ways that you can commit a felony in Florida. Trust me, it's probably in the range of a couple of hundred ways that you can commit felonies in Florida under the loose criteria that our legislature has through all these laws. And this is what I was going back with the book, the new Jim Crow that it's got. This was part of the plan executed by Southern legislators post-Civil War. This was the means by which they openly and brazenly said, we are going to take away their rights to vote, there being the African Americans, to maintain white supremacy. That is what the foundation of our criminal justice system is built upon, and there's racial bias and discrimination that has become such a part of our criminal justice system, from the way the laws that are passed, from the first appearances that Larry is talking about, where if you're poor and a minority, you're much more likely to be detained or have a very high bond before you get out of jail, and then it's a snowball effect from there. So this is a multifaceted process by which we have used the criminal justice system and the felon disenfranchisement and the apportionment laws in Florida to achieve an outcome that we are currently in the framework that we have. So Amendments 5 and 6 are one tool that restructures that gives us the opportunity, the citizens, you, to change that structure. There's a lot more that we could do, and the best method by which to do it is constitutional amendments, but of course that takes 60% in Florida, and through targeted litigation that attempts to strike down these onerous laws. Yes, in the back.
Oh, you're pointing to me. Okay, my question is regarding the public defender. You touched on it briefly, but I saw a special on cable recently about the tremendous workload. It seems to be a nationwide problem. So I guess my question is, do we compare less favorably regarding a public defender ratio? And do you have any suggestions? What would you need to fix it?
The next time you invite me, I'll tell you. I'll go into the details. There's no question. Again, depending upon the standards that you set, and we looked at the ABA, and the ABA set standards that, if I'm not mistaken, that 50 cases should be a single individual. My felony attorneys are carrying actively caseloads that range between 100 and 150 cases. My misdemeanor attorneys are handling a caseload that range about between 220 to 260. So that is the number. Now, again, they do an outstanding job, and I think that once you've been indoctrinated into the public defender system, if you don't have a large caseload, you don't know what to do with your time, but you learn how to triage and work the cases, but there's no question. The Public Defenders Association, of which I'm a member, which is the 20 elected public defenders, 19 participate, we just completed a weighted caseload study so that we can give an accurate assessment, so that we can go to the legislature and say, with empirical data, this is what we need. Are we going to get it? Not likely. Will they give us some? We can only hope. And we play the hand that we're dealt. And I think that we play it extraordinarily well. That's not to say that there's not wastes. I mean, that's why I addressed the issue of mental illness within the criminal justice system. And, you know, the same question is asked, what can we do with the monies? And if you certainly want to get me off on a tangent, you know, we have a very limited, we're on the bottom rung again in the state of Florida. We are 49 out of 50 states as far as spending on mental health issues. And yet, and I don't have the percentage with me, but approximately $200 to $210 million of that budget, and I believe it, and again, I hate the fact that the newspaper here and that there's a television to record this so I can be misquoted, but I want to say that it's, I believe, 1/3 of the budget dedicated to mental health issues is for competency restoration. And that means if my client appears to be incompetent, I file the suggestion of incompetency, and they're not given treatment, they're given training so they can come back to answer to the charge. That's where between $200 and $210 million of our stingy mental health budget goes to. So I see tremendous wastes within the system. As you said, the criminalization of things, the draconian sentences that are handed out. I mean, we're working hard within this community to establish diversionary programs. We're trying to address the issue of homelessness so that we're not criminalizing it. There's a very good series that's going on in the Herald Tribune right now on mental illness and how it's treated in this state. You know, 50% of those individuals who check in to Florida State Prison have been diagnosed with a mental disease in need of treatment, of which they get little to none. We have, not that that's always an excuse for your behavior, but are we going to address the problem? Because just like everyone else, they're eventually going to be released. And my best bet is, if you're suffering from a mental illness, it doesn't get better through incarceration, and you're going to be released onto the streets, and what's going to happen there? So the recidivism rate on that is through the roof. But yes, I certainly look at things trying to be as fiscally conservative as possible, and also looking towards public safety as an objective that we all want and share. And I think Michael hit it on best of all. You re-enfranchise, not disenfranchise. You re-engage, you integrate, and you find the recidivism rate dropping considerably. You don't alienate, you don't make everything so onerous that you're left with nothing except a life of crime. And I know that that sounds like I'm just making excuses, but that's just the reality.
We are paying your taxes. Our taxes are paying for the public defender, but our taxes also pay for the prosecutors. And I think there is not a good balance between how much money the prosecutors
I swear to God,
get.
I didn't pay you to say these things. I just want the disclaimer to be made.
But isn't there some way to balance that out?
We are duking it out with the legislature. That's the reason that we had the weighted caseload study, which is also the reason why the State Attorneys Association did not want to participate in a weighted caseload study. We wanted to have empirical data to be able to present to the legislature as to what the true costs are. Because up until now, there's like this magic formula that has been utilized by the legislature that for every dollar the State's Attorneys Association gets for their budget, we get 50 cents. So it's, and you can, it's where the, it's a matter of what the general public feels is important. And public safety is of paramount importance. I try to explain to people that what I'm trying to do, I believe, enhances public safety.
If we could go back to the petitions, I have a two-part question. Number one, is there an expiration date on the current petitions that have been signed?
The answer is yes. And that date, as I understand it, there's a soft date and there's a hard date, because the soft date is the date by which you need to have so many petitions signed to formally petition the Florida Supreme Court to say, please review that. That soft date, I've been told, and we moved it back, originally it was June of this year. That came and went. We did not have the signatures. The new soft date is, as I'm told, January of 2016. That doesn't give us the optimum time to have the Florida Supreme Court review the petition language and offer an opinion, but it's potentially doable. But I think that is both a soft and hard date that you have to have it in by that point in time. But a follow-up to that is that, okay, yes, those signatures will expire. We can't use them for a new ballot or initiative down the road. But we have the names, we have contact information, and that is what's being also worked on at this time, because we want to make sure we take advantage of the great efforts that have already been done with this petition drive, should we look at 2018 or 2020 to resurrect it in a broader appeal.
And the follow-up question, where are you right now in terms of the total number, approximately the total numbers that have been turned in already? And is it 600,000 signatures?
It's 600,000 signatures and some change is what's needed. And the last count that I had was that we were just shy of 500,000.
My name is Laura Wallace. And you know, it really saddens my heart when I hear the things that you've said that affect blacks. And I think about the young single black females and the young men that are in prison. And when they come out, they've served their time, and then they can't get a good job. And I mean, people sit in their offices and make laws to, because your color skin is different, to judge you and to say that you're going to have a felony that's going to keep you from ever voting again, ever having a right again. That is so wrong. It is. And I know it just doesn't affect blacks, but it does Hispanics and poor whites, but mainly blacks. And that's sad. That really saddens my heart. So I want to know, at this point, what can blacks do to try to work and to improve that? Because when I know how important voting is. I know that voting is important. But I tell you, that really needs to be fixed in America.
Well, my quick answer is, if you look at any statistics of elections over to, and it probably goes back, but more recently, the rate of voter turnout among the youth in this country is pathetic. It is less than, I think, 9% of eligible voters between the age of 18 and 30 vote in elections. We have to educate our youth about how vital it is to exercise that right. We have to look at laws like in Australia, where make it mandatory to vote. Other things, but primarily, I think, education. We have to educate our youth about the origins of these pervasive laws that keep African Americans and people from poverty having the opportunities that others do. I think that's probably the most vital way to do it, to educate them, because when people are educated about the facts, I think they tend to make really good judgments and decisions. And a lot of this history has been obscured through, oh, well, we're tough on crime, and these people have committed crimes, and so forth. We have to educate not only about the origin of these laws, but that forgiveness People make mistakes, and we don't just throw them out and discard them and not expect them to be contributing members of society again.
I'd like to point out that this is probably a group that is most dependent upon we, the people, to fix this. They don't have money to contribute to campaigns, and maybe they'd like to vote, but they can't. So it's going to take a lot of people saying they want this to happen. And I'd also like to point out that the legislature can put an amendment on the ballot like that. And there is a bill to do that, but it's going nowhere. But that's another avenue. Okay, someone over here was first. Yeah.
My question is, I understand that they have lost their right to vote, but have they also lost their right to sign these petitions?
Yes, you must be a registered voter to sign those petitions. So they can't even participate in the process by which to change the law, which is another sad part.
Given the power of the black church and the importance of ministers in the black community, have you, I imagine you've been working, assuming at Sunday services afterwards people could sign a petition, but I would think there would be such motivation, what do I know, maybe you didn't get motivation from black leadership, that you could have an astonishing number of petitions signed fairly quickly, but maybe I'm underestimating how difficult the whole process is.
Well, the process by which this constitutional amendment drive got off to a shaky start. And I'm not sure of the reasons why. Perhaps your leadership knows, but at some point during this process, the League of Women Voters decided that they were going to put their eggs in another basket for another date. Now, they haven't abandoned this petition drive, and neither has the ACLU, but at some point we realized, and it was over this past summer, that it was very unlikely that we were going to make our target, our soft date, or even a hard date for a number of petition drives. So we're going back to the drawing board on that in terms of what we've learned from this process, what we can do better. I was at an executive committee meeting this weekend in Miami, and the ACLU, this is going to be felon disenfranchisement laws, and looking at the various ways by which we can attack them, overturn them, is going to be a top priority over next year and the year after until we defeat them. So we will learn from some mistakes that have been made in this particular campaign, and we will come back at it. That's just what we do. We're not going to turn away from this, but that is a good example of getting the signatures and so forth. Frankly, the petition signature drive in Florida, to get that 600 and some odd thousand, you can't do it without a paid professional staff campaign, and that takes, at a minimum in Florida, it's about a $5 million campaign. So we're looking at this. We're actually preparing, meeting with donors even outside the state of Florida, other organizations that are wanting to help overturn this law, because it's well known across the country that Florida is the most onerous and disenfranchises the most of any other state by far. So we're looking at raising money for this to go back at it and approach it from a much more dedicated point of view.
You know, the one.
We're about finished. Maybe one more comment or question. If it's quick.
I want to go back to when you were earlier talking about the states that do take away the voting rights. And I wondered, like you said, Iowa, how different is it there from here? I mean, what is the limit of when they take away their voting rights at those other two states?
Do you know?
I don't know.
You don't.
I don't know.
But I did want to follow up with the one point that I thought was interesting, and to follow on what Michael said, is that what I find frustrating is the not permanent, but the disenfranchisement of such a huge segment of this population that has the right to vote, and that we have disengaged the youth of this country so that they have the right to vote, and yet they don't participate. So in examining, I'm clearly advocating for the restoration of civil rights for individuals once they have finished their sentence. I'm not advocating what they do in Vermont, for instance. But trying to activate the youth of this country who are going to inherit all of my mistakes, they don't want to participate. And that's my frustration, because time and time again we keep talking about the youth vote, get out the youth vote, and it never seems to take, what is it about our political system? And you can force people to vote, and I would advocate that as long as there was one slot that indicated none of the above. Because I don't think that you should be forced to vote for a candidate that you don't believe in. And I think that you shouldn't leave it blank either. I think there should be known that I am dissatisfied with any and all of the candidates. That should be a viable option. But having said that, I guess I'll give Michael the final word.
I want us to thank our guests. We've run out of time. METV has another engagement today, so we're going to wrap it up. And I just think they've done a wonderful job of educating us on this issue. Thank you. We also thank the Bradenton Women's Club for the use of their facility, and for METV for taping our show for later broadcast. You can watch their program online. Their website is www.metvweb.com. See also our website, lwvmanatee.org. And we also encourage you to join our league. We have forms on the front table, and we don't have a hot topic in December, but we will be going to the One Stop Center for the Homeless. We're going to have a tour on December the 9th, and there's information on that on the front table. Let us know if you want to go with us. Okay, thank you very much.